Please.
Yes. So, good afternoon, everyone. Welcome to Asian Exporters Chamber of Commerce and Industry International Arbitration Centre, authorized by the Ministry of Commerce and Industry, Government of India. I am Advocate Rohini, representing legal wing of AECCI, and joining with me Ms. Swarn, Executive Director of AECCI, who will be assisting in facilitating today's session. And under the esteemed leadership of our Honorable Board Chairman, Mr. Jahir Bukhari, AECCI has been at the forefront of empowering exporters, promoting international trade, and offering legal support to businesses. It's my privilege to host this section. We aim to facilitate a deeper understanding of arbitration, a pathway to resolve trade dispute and driving business growth. Today, we have Honorable Dr. Anup Wadhawan, retired IAS officer and former Secretary, Government of India, and also served in various roles at Department of Commerce, Director General of Foreign Trade, Department of Financial Services, Department of Economic Affairs, and Prime Minister's Office. With extensive experience in trade policy and economic governance, Dr. Anup Wadhawan has played an important role in shaping India's foreign trade strategies. He has served as an executive magistrate and has vast experience in arbitration, conciliation, and commercial dispute resolution. Currently, he is empaneled as a member of the arbitration panel for the National Highways Authority of India and also served as a sole arbitrator for Government of Uttarakhand and has contributed to dispute resolution in multiple PSU contractual matters, and he is on the board of various companies in insurance, finance, and NGO sectors. His deep expertise in various trade, finance, banking, insurance, capital, and many more sectors is invaluable for today's discussion on arbitration. And sir, we are proud and privileged to have you in panel with AECCI IAC panel of arbitrator, and it's our honor to have you, sir, with us today. Next, our Executive Director, Ms. Swarnalada, will give you an introduction about AECCI International Arbitration Centre.
Thank you, Rohini, and good afternoon, sir. This is truly a pleasure, a great honor to AECCI and to all of us to have you with us today. And
thank you so much.
Yeah, sir. Thank you for sparing the time to be with us today. And before moving ahead with the session, let me briefly introduce the audience to AECCI and its International Arbitration Centre. So AECCI, that is Asian Exporters Chamber of Commerce and Industry. Most of the people would already be aware of AECCI then too. This is a decade-old non-profitable organization, and we are proudly recognized by the Ministry of Commerce and Industry, Government of India, to certify the origin of goods being exported from India. That way, in line with the government's objective, we are working very hard to promote and protect the trade and industry here. Our mission is to serve the needs of exporters and importers and helping them handling their complex trade issues. At AECCI, sir, we have established various wings. We are having our business advice wing, our export wing, and of course, this legal wing. Under legal wing only, this particular program is being organized today. At AECCI, we are committed to, I would say, promote the safe and fair trade practices. For that, we keep coming up with various initiatives. We keep organizing different programs just to make people aware about the right practices, right trade practices, and to make them aware about the trade policies, trade procedures. One important aspect of the trade is nowadays so many issues come to us regarding the trade disputes. So this is very important to know what are the right practices, and if they ever get stuck with some trade dispute, what type of remedies they can take. So for all this, we keep taking the different initiatives, and one such initiative is the inception of our International Arbitration Centre. That was actually founded in 2019, and since 2023, we have got operational. So we are having expert arbitrators, highly designated, I would say, arbitrators associated with us, and they are empaneled with AECCI IAC. Today, we are having Honorable, I would say, respected Dr. Anup Wadhawan, and Rohini has already given a very nice introduction of Sir. So today with Sir, we would be gaining the knowledge about the right things to follow and what role actually arbitration plays, I would say. It is not just to resolve the trade disputes, rather this is also a kind of, I would say, to strengthen the business ties between two parties. So today with Sir's rich experience, we'll gain the insight on arbitration, and either you are an exporter, corporate governance, you are into corporate governance, or entrepreneur, in whichever sector of the business you are, today's session is going to be very beneficial for you all. So I would hand over back to Rohini. Rohini, please take ahead the session. Yeah.
So thank you for the great introduction of ACCA, ma'am. And so this session is mainly to address your concerns and to provide an expert guidance and enhance the understanding of legal framework of arbitration. So without delay, let's begin with our first query. So, sir, in your experience, what are the common challenges faced by Indian SMEs and MSMEs when engaging in arbitration? How can the process be made more accessible for the exporters?
Right. So thank you so much to Rohini and to Swandhata ji for the very kind introduction and this valuable and wonderful opportunity to be with all of you. Yeah, so clearly, MSMEs, in terms of limitations on their capacities and resources, face, particular difficulties in accessing arbitration as a alternative dispute resolution mechanism, firstly, in terms of cost. A typical institutional arbitration can be very expensive. So that is one forbidding aspect. Then, it is complex. It is bound to some extent in legal requirements and legal complexities. So sometimes MSMEs don't have access to the kind of resources to navigate those, legal complexities. There's also lack of awareness amongst MSMEs on the options they have, starting from mediation, conciliation to arbitration, a full-fledged legal dispute. How do you weigh these options, and how do you optimize your strategy to, get your legal rights fulfilled, while minimizing cost and time. So they sometimes don't have awareness of those options. Then, of course, arbitration is, plagued at times with delays for various reasons, judicial interference, time taken in execution of the awards, and delays again are very costly for MSMEs. Sometimes the MSME business is financially fragile. You don't have time, for that dispute to be resolved. In the meanwhile, you'll go financially under if the dispute is not quickly resolved. So delays are a concern. And as I mentioned, enforcement is a concern. Once you win a arbitration, then enforcing it is another legal obstacle that you have to cross. And then, of course, very often your adversaries are exactly on the opposite end of that spectrum. The adversary might be a very resourced, big MNC or a big institution or a big commercial entity, and all your weaknesses are matched on the other side by commensurate strengths in all these areas, access to legal resources. So that again is an issue. And because of all these reasons, very often MSMEs will adopt ad hoc arbitration proceedings within the flexibility that the Act gives them, and not institutional arbitration that ends up being expensive and time consuming. But then sometimes because of the ad hoc arbitration, enforcement becomes difficult. There might be procedural inconsistencies. A court of law will, set it aside. So all these are the main issues, which I think MSMEs face in accessing arbitration as an option.
Yes, sir. So thank you for sharing your insights on challenges faced by
Indian
SMEs.
The solutions are logically there. The Arbitration Act gives you a lot of flexibility. So within an institutional arrangement, MSMEs can be assisted, by industry bodies, by government, by bodies like AECCI. They can be assisted in accessing a template which is cheaper, a template which is quick, a template where a lot of legal security is there, and which gives them comfort that okay, this is a good, robust process, At the same time, it is, cost effective. So that is what we need to work
Right.
towards. Institutions like AECCI need a template. And of course, you
Right.
access the template within the Arbitration Act. But then the Arbitration Act itself gives you a lot of flexibility based on
Right.
mutual agreement.
Right.
So let us say an MSME is entering into a contract with some overseas buyer or entering into a contract with someone even domestically, then there should be an understanding that, okay, this contract will be under this particular arbitration framework, which has been worked out for the MSMEs. And then if it has government backing, if it has institutional backing from industry bodies, then both parties, will be willing to adopt that framework. And to the extent that framework is simple, quick, cost effective, it will help the MSME.
Right.
So
Right, sir.
with these problems I mentioned, the solutions are also there
Right.
in the flexibility that the Arbitration Act itself affords for arrangements to be worked out based on mutual consent between the parties.
Right, sir.
So that's my
And
Yes, sir. So,
as per, yeah. Please, Rohini.
yes, ma'am.
Yeah, please go on.
Yes, yes. So, some technical issue with ma'am. Okay, so regarding this, sir, thank you for your valuable insights of the challenges faced by Indian SMEs and MSMEs in arbitration. Actually, the lack of awareness regarding this for the arbitration and solutions also is an important thing for the parties to come up for an arbitration and to add an arbitration clause in the agreements and all. So, thank you so much, sir. So, should I move to my next question?
Sure.
Yes. So what role do arbitrators play in shaping the outcome of a dispute, and how can they maintain a neutrality in complex cases?
Arbitrators function like judges. They function like
Right.
judges. They function under a legal framework, which is agreed between the parties. It can be a legal framework of a particular jurisdiction. It can be Indian jurisdiction, can be an overseas jurisdiction. But arbitrators work like judges under a legal framework, but a legal framework which gives more flexibility, which is
Right.
less, rigorous in terms of process as compared to a full-fledged judicial process. And so all the ethical rules that a judge is bound by, an arbitrator is bound by the same ethical rules. They must be completely neutral. Any conflict of
Right.
interest they have should be brought out right up front. They should be non-discriminatory across the parties
Right.
in giving them fair opportunity, equal opportunity, in giving them procedural accommodation. Typically,
Right.
parties face difficulties. Our witness won't come today, or this evidence we are still trying to gather. Give us time. So you must be flexible. You can't, arbitrarily disallow a request which will undermine the legal interest of that particular party. You have to be
Right.
totally fair, accommodating, on an unbiased, equal basis for both parties. And needless to say, you have to remain principled. You can't adopt any,
Right.
unprincipled practice, which
Hmm.
is criminal in nature, or even
Right.
otherwise unethical in nature. No such practice can be adopted. You have to remain independent from external influence. If there's pressure, let us say one of the parties is a government party, so no pressure from government can be entertained. One of the parties is a very influential corporation, no pressure can be entertained. Or there is some
Right.
very influential party, no pressure can be entertained. And to the extent such pressure comes, you have to immediately report it to the institution concerned
Right.
and deal with that situation. And of course, typically you have multi-member arbitral panels. So the multi-member panel balance each other, the members balance each other, and to the extent any one of the members is a deviant in terms of having the highest integrity, having the highest ethical standard, then a panel will keep a check on that.
Right.
So you are a check on your fellow arbitrators also,
Hmm.
that they must be logical and fair and balanced in their approach.
Okay.
So that makes a big difference. And of course, the lesson for a party is that choose the right person Don't choose a person whose ethics are suspect. Don't choose a person who promises, that I will fix the matter and give you a favorable solution with all sorts of unethical
Right.
methods.
Yes. Right.
Always choose a good person with high integrity.
Right.
And then, of course, an arbitrator must avoid ex-party communication. You can't communicate with one party.
Okay.
Right.
Even these days, of course, arbitration is happening virtually. We are using virtual platforms, using email for submission of evidence and everything. So
Yes.
there again, I've been doing arbitration. The strict rule is that you have to respond by email using the trail mail, one trail of
Right.
emails, and you have to do reply all.
Right.
Everyone gets copied. You can't just communicate with the arbitrator and not, communicate with the other parties. So no
Right.
ex-party communication.
Okay.
And then, you're strictly guided by interpreting the contract and interpreting the law and then
Right.
enforcing the law. So the contract becomes very important. You have to be fair and in some ways you have to take the literal language of the contract and of course read its intent also. Sometimes the contract language might be ambiguous, but then what is the logical intent of that framing of the
Right.
contract? You have to understand
Right.
that. And so in a sense, you have a framework within which you are bound to, in some way give justice. You stick to the structure of the contract and the law. And of course, then you're expected when you pass an order to pass a reasoned order. You must
Right.
discuss all the evidence, statements of witnesses, documents submitted. You must address all the points raised by each party. One party is saying, well, this is my claim based on all these facts. Other party is saying, this is my claim based on all these facts. And to the extent you're ruling in favor of someone, then you analyze the arguments of the other party and give a logical reason why you don't agree with them or why you
Right.
agree with them partly and why you agree with the arguments of the side whom you are tending to rule in favor of.
Right.
So all that becomes important. And then, at some level, arbitrators must also be facilitators. You should encourage some way the discussion also where parties see a balanced middle sometimes. A lot of times parties will come to an understanding on some of the issues that, yeah, we understand that, this is a fair outcome on this. So that helps. If you're able to make both parties see reason and arrive at a accepted middle ground, that is really done in conciliation. But here also, if broadly that understanding emerges, then you will also have an idea as to what is the fair order in this case. And the order will be fair, it will be well accepted, it will be welcomed by both parties. So that again is helpful. And so basically, you have to be principled, upright, fair, unbiased between both parties, and apply your common sense to understand the contract, understand the law, and apply them fairly. So that is what is expected of arbitrators. It comes instinctively. It is not that you have to keep remembering all these things, but when you work as an arbitrator, it comes instinctively. There's a famous story by Premchand called Panch Parmeshwar. I think all judges, arbitrators should be made to read that story
Okay, sir.
before they sit on a platform to pass justice. I won't recount the story, but it is worth reading.
Okay, sir. I'll also read that.
Yeah.
And in fact, and from a business point of view, I would say choosing the right arbitrator, the principled, as you said, the qualities that he should have, all that should be considered by choosing them. And drafting the agreement is also equally important because your agreement comes into picture before the arbitrator comes, right, sir?
Yeah.
So that is also one of the very important aspect.
Absolutely.
Please.
Agreement has to be drawn out carefully. Your options have to be weighed carefully.
Yes.
So agreement is,
Right.
yeah, as you're saying, the starting point, and it will lay down the framework for the arbitration as to what law will apply and what procedure will apply.
Right.
That is right. That is
Right.
very important.
Yes, sir.
Yes, sir. So thank you so much for your clear reply for the role of arbitrators and the importance of neutrality in complex cases. So moving to my next one, that's how can Indian arbitration centers better cater for the need of international clients especially when dealing with cross-border disputes?
Yeah. Yeah. So you see, basically, what is the client looking for in an arbitration setup? We have to understand it from the point of view of the client. It is, typical marketing philosophy that put yourself in the shoes of the consumer. What does the consumer want?
Mm.
So the consumers want, good facilities. Consumers want simple processes.
Mhm.
Consumers want speedy outcomes. So the process should have a time-bound, speedy outcome. It should be simple to that extent.
Yes.
Consumers want, minimal legal complications. So to the extent, courts have a tendency to interfere, and India also the tendency might be there, interfere during the process. Of course, that happens minimally,
Mm.
but interfere then at the end of the process under Article Section 24, 34, they can set aside a order or
The arbitral
interfere
award,
at the
yes.
time of implementation. Yeah, to the extent that implementation of the award, to the extent that happens, then they have to be confident that in this environment that will be minimal and that will be fair and quick. So India needs to reform all these aspects, create state-of-the-art facilities, good connectivity, whether it's internet or electronic transmission of documents, storage of documents, transcribing the proceedings, maybe through AI approaches, safeguarding the documents,
Mhm.
safeguarding the data, maintaining privacy,
Okay.
secrecy. So all that infrastructure is required.
Mm.
And then, of course, the rules, as you're saying that the rules can be laid down. And then if two parties use that platform, then they are bound by those rules. Those
Right.
rules should be fair, they should be simple, they should
Mm.
have timelines so
Right.
that the whole process is over within 3 to 6 months. And then to the extent our courts can cause a delay, government has to create maybe special courts, international arbitration courts or arbitration courts where any matter which then goes to an arbitration court is quickly decided.
Yes, sir.
So all those aspects need to be taken care of to make, and you only have to study the successful countries, study Singapore, study London, all these
Mhm.
international bodies. What are the rules they follow? We can copy the good practices to some extent, to the extent they suit us. Then you have the International Bar Association, they have their own rules. You have
Right.
UNITRAL, UN Commission for International Trade Law.
Yes, sir.
So all these, all this received wisdom is there for us to, evolve a really good template
Right.
which meets all these needs of the clients,
Mhm.
and that will make it attractive for parties to come under Indian jurisdiction or come under an Indian institutional framework.
Mhm.
Even in an Indian institutional framework, the jurisdiction can be overseas.
Right.
A Singapore party can say, okay, I'll come under Indian
Indian.
institutional arrangement,
Right.
but the law of Singapore will apply or law of Europe will apply. Even that flexibility is possible. Or two third parties, one of Singapore, one of UK, chooses India as the destination. Like they do in Singapore, they do in London and all. Parties from two different countries will come to London or come to Singapore
Right.
and do the
Right.
arbitration. So I think the things we have to do at one level are quite obvious.
Mhm.
And to the extent various countries and locations have done it already, it is not
Okay.
hard to achieve if we systematically
Mm.
get on it. And I think the Asian Exporters Organization, the AECCI, they have a golden opportunity to create a platform like this.
Right, sir.
Mm.
And then work with government to maybe have special courts and all also
Yes, sir.
to make sure there is no
Uh-huh.
legal risk. So there's an opportunity for AECCI to create in your arbitration center
Right.
this kind of a globally attractive framework.
Yes,
So
sir.
that will be my
Right, sir.
response on this.
Thank you, sir. And this session we will, of course, take forward to the management also. And I would add to this, we have already started working in this direction. That is also one of the thing. Very soon it will be shared with you all. So we are working internally on that, and we really want to take this ahead. This is very important that India should be known for a good place for arbitration and better infrastructure, and of course the quick process. All that has to be part of that. So we are framing out some suggestions, and that we are going to submit to Government of India. And this particular suggestion, of course, I'll ensure that this is taken to our management and should be considered.
Yes, adding to that, the rules of IEC and all, it's very important to essential for making India as a preferred arbitrational hub.
Mhm.
So moving to my next question, that sir, if the parties involved do not have an evidence of contract or transaction or a supporting documents for the supplies or realization of payments, how IEC can handle the dispute between the parties?
You see, the legal framework across the world and framework also for arbitration gives a lot of flexibility in that. Like even contracts, for instance, contract can be a verbal contract. Then you can prove the contract through various, sort of circumstantial evidences or, peripheral facts and evidences. So you don't need not always have, contractual documents or other, very firm and strict documentation for an arbitration to go ahead and be decided. It can be decided, of course, relying on legal principles, relying on circumstantial evidence, relying on arbitral discretion. There's a lot of arbitral discretion based on some underlying legal principles, common sense, logical reasoning. So all those issues can be, all those aspects can be invoked in deciding on arbitration where the documentation is very weak or, non-existent. You can rely, of course, on witnesses. Let us say there's a contract between a party which is not written, but some relationship has been there between two parties. You can bring witnesses who can demonstrate, who can prove. To the extent there are some bank statements, financial records, payment receipts, GST documents, tax documents. Those documents can be brought in. To the extent there is electronic communication, whether on WhatsApp or otherwise, there is any other electronic exchange, all that can be brought in. And to the extent some, arrangements are customary in a certain industry. Certain industry has some practices where, based on word of mouth, based on, what they call kacha chithas, some trade happens, some exchange happens, then those practices also can be, brought before the arbitral panel, and they can be proved through all these indirect means. And of course, affidavits, sworn statements, and all those affidavits and sworn statements, you can have cross-examination of the submitter. To get cross-examination, you can establish the veracity and the credibility of that statement. Expert opinions, third-party opinions, from chartered accountants, auditors, etc. And then, above all, in some cases where a party says that I don't have documents, cannot produce the documents which should logically be there. So somewhere a party is trying to hide documents to, deny the case to the other party, then the court or the arbitrator can take an adverse inference that this is a document which should logically be there with the person. To the extent the person is not producing it, you can take an adverse, inference based on that non-production of the document. So these are some of the ways in which arbitration can proceed quite credibly, with great credibility and fairness, and ultimately it can lead to fair outcomes for the parties, notwithstanding the absence of documents.
Means for each and everything, documentary proofs must be there. And sir, one thing, as you said, electronic communication, does it play a role in that, sir? Means your electronic exchange over WhatsApp or on any other mode apart from email, would it be considered as an evidence?
then you can prove that through indirect means, through other documents. Let us say you are sending goods to some person,
Right.
but you don't have a contract
Right.
or an e-challan, So all those documents will use. So WhatsApp and all, you see, the thing is that the judicial verdict on WhatsApp and all is mixed. There have been cases where courts have thrown out WhatsApp evidence, that WhatsApp evidence by itself is not sufficient.
Okay.
There should be
Right.
corroborative other
Right.
evidence in support of WhatsApp. But then a lot of cases, governments have launched prosecutions based on WhatsApp evidence. So certainly, depending on the sum total of the evidence available
Right.
and the credibility of the sum total of the evidence,
Right.
then I think WhatsApp evidence can be read
Okay.
with that.
Right.
Okay.
So WhatsApp evidence can be read with that, and then you can, sometimes forensically get it verified. Let us say the other party is objecting to it. But no,
Yes, sir.
this is not credible. Then the party submitting the evidence can give a forensic certificate to say that no, this is authentic.
Right.
So the message actually is changed. So I think it has its value, and that value will increase over time.
Okay.
It's a recent practice, WhatsApp and SMS and all. It's a recent practice. We still not absorbed it fully.
Yes, sir.
But
Right.
as time progresses, I think it will get more and more prevalent.
Right.
Yes, yes, sir.
So being
So
an export
without formal,
trader,
if
yeah,
there is no formal document.
please,
Pardon?
Rohini.
Yes, ma'am.
Go ahead, Rohini.
Yes, I'm saying that is there this absence of formal doc? Yes, ma'am. Am I audible?
Yes, yes, you are.
Yes. Okay. So in the absence of formal documentation also, then the traders to understand how the arbitration disputes can be resolved. Right? So that's
And
it, ma'am.
basically, you have to present your best case possible. See, you have to
Right.
present your best case possible. If you don't have certain conventional accepted document, they're lost for whatever reason, then you have to present your best case possible. What is the evidence you have? There'll be some witnesses, there'll be some other documentation, there'll be some indirect evidence. So all that you have to use.
Yes, yes, yes. So moving to my next question, sir. So if there are claims arising out of more than one contract and the preference of the claim is to be heard on one proceeding, so how the arbitrations be commenced in if the thing is like that?
Yeah, so you see, as I mentioned, the arbitration law gives you a lot of flexibility based on mutual consent.
Right.
So if there are contracts involving multiple parties which are related on either side, if the relationship involves multiple contracts between the same or the related parties, and the parties feel that it will be sent, and the dispute in some senses is related and has some underlying common elements across those contracts, across those parties, then if the parties mutually agree, all those matters can be heard in a single arbitration.
Right.
And so mutual consent is a big thing. You see, in arbitration law, with mutual consent, you can work out that arrangement. And then even the law, I think, encourages consolidation of arbitrations. I think there is all the international forums, institutional forums like SIAC, ICC, MCIA, all those forums allow consolidation. In Indian law also, I think Section 7 allows joinder of parties in these cases. And sometimes you can refer to a matter to a court of law also to invoke the Arbitration Act and sort of consolidate these cases in a single arbitration. So certainly that, and it makes sense. It makes sense because when parties are related, the matters are similar in nature. They have to be decided on similar principles, on similar lines. There's no point, deciding them in separate arbitrations or deciding some of them today and then the rest tomorrow. So certainly that opportunity is there, and I think it should be used, by the party.
Okay.
Okay. For the clear
And
explanation how to
even
handle multiple claims.
midstream it can happen. Midstream, let us say our arbitration is ongoing and you
Okay.
discover these opportunities, or you discover there's a third party which was primarily involved in the execution of the contract, and that person should become a party also. Then the arbitrator has the power to include that entity also with mutual consent. Or
Okay.
if there is no mutual consent, then one of the parties which is interested in that can go to a court of law and
Okay.
get an order,
Okay, sir.
get that party.
Okay.
So there's a lot of flexibility.
Mm.
Rohini, I
It's
guess
very
you are
important.
a lawyer, Rohini, of course, and
Yes, I am lawyer, sir.
Swarnlata may be a lawyer also. So if I'm wrong
So I'm
anywhere,
not.
do correct
So
me.
let me tell you, sir, I'm into means sort of your field. I look after this foreign trade policy part only. So, and I generally during my trainings and all, I try that people should be aware of. Means I always tell them don't use WhatsApp and all. Just create your documentary proofs and all.
You're right in saying that. You're right in saying that. WhatsApp
Means,
is not a preferred means of communication.
right,
It
sir.
should,
Right,
in the
sir.
very least, be an email. In the very least, it
Email.
should be an
Because in the
email.
front of the court,
Yeah.
yes.
Yes.
And ideally, it should be a, registered post or something with acknowledgement due, or, with record of receipt.
Right.
So I agree with you. I'm not saying that WhatsApp
No,
should
sir, that's
become a
perfectly
preferred.
all right.
Yeah.
This is just
But if,
addition to my knowledge also.
yeah, no, but if you have in some circumstances used WhatsApp,
Correct.
then I'm sure it'll come in useful.
Yes, we'll consider as a secondary evidence also, sir, right?
Yeah.
Yes.
So the initial exchange, we can say we can start on the WhatsApp or other means, but finally we should bring all type of transactions on the paper only. Right.
Right.
Yeah.
Because
I
in front of the
paper,
court, there what's the communications will be considered as
yeah.
a secondary evidence only. So
Yeah,
mostly,
you can send the paper by registered post. You can also
right.
scan it and send it by email.
Right.
So,
Right.
various, and you're right. Sometimes it is very important to be very cautious in these matters. Then later it comes back to bite you later. You
Right.
make some small omissions. You trust the other party beyond reasonable degree, and then you regret it later.
Right. When the dispute arises.
Yeah, when you're trying to enforce your legal right, then your case is weak for all these.
Right.
Right.
Great.
Yes, sir. So next one is, and the final one is that, sir. So what if it is determined midway through the arbitration proceedings that the quantum of claim or the counterclaim is more or less than the original estimation?
Yeah, so certainly, again, there is flexibility to make that accommodation. If you discover after submitting the claim and the counterclaim that some new evidence has come in, or something had got missed out, then there is opportunity to make amendments to the claims and the counterclaims. I think in the Arbitration Act, the Section 23, subsection 3 is there, which allows parties to amend or supplement their claims and counterclaims, subject to the tribunal approval, of course. And tribunal can permit changes, unless, of course, the amendment is going to cause undue delay. It will start off a new line of proceeding, and a proceeding which was close to conclusion will now, get very delayed. Then the arbitrator might say, well, you bring that in a fresh case or something, or it is something very prejudicial to the other party, and the first party should have rightfully brought it up in the first instance. So arbitrators have a lot of flexibility in that. Of course, then that will be subject to judicial review. But in principle, the opportunity is there basically. And or sometimes the arbitration agreement will be such that an amendment is prohibited. If both parties agreed, in that case it will not happen. But otherwise, there is flexibility to make amendments to the claims and the counterclaims. Then, as you would know, the charges of the arbitrators are sometimes based on the volume of the claim and the counterclaim.
Yes,
So
sir.
then those charges will also be amended. They can be amended downwards if the claim is being revised downwards. Counterclaim is revised downwards, they'll be adjusted downwards, and otherwise, upwards.
Yes, sir.
So,
Yes.
so certainly those.
This is important, yes. And the
Yes, sir.
arbitrator will also vary accordingly, right?
Yeah.
Okay.
But ideally, you should, be very thorough, as you mentioned, that the arbitration order, arbitration agreement is very important. So you should be very thorough at that time in understanding your entire claim, understanding its entire scope, understanding the implications of what you agree to, implications of whatever you say in that arbitration agreement.
Right.
So it becomes very important.
Yes. So the party should be very conscious while preparing an agreement for this arbitration.
Yeah, so you include all your claims there, and so you don't have to down the road then face that difficulty that want something else included or something corrected, and you face difficulty. So the other party is likely to oppose it.
Okay.
They are likely to oppose it.
Right.
Right, sir. Yes.
Some sort of estoppel applies on that. So that can
yes, sir.
So by mutual consent, this can be changed, means changes can
amended,
be, but
yes.
it is always, yes.
By mutual consent, and I think the arbitrator also has some powers. They also have powers to hear the parties and say, okay, no, it makes logical sense to allow this amendment. And then, of course, the party which feels adversely impacted,
yes,
they can go to a court of law. That possibility is there.
Okay.
But
Okay, sir. So
in principle, if the arbitrator is fair and reasonable and gives a logical reason for his or her order, then the other party will also not go to a court of law easily. They will know that the court will also, in the interest of justice, in the interest of finality of litigation, there are two very important principles.
Right.
The parties must get justice, and there has to be finality of litigation.
Okay.
Litigation can't be endless. So in that interest, the court will also say that no, it makes sense that these changes be allowed, and then the matter be decided in entirety, once and for all in this proceeding itself. So,
okay, sir. Sir, if the arbitrator disagrees for the change or amendment in the arbitration agreement, so if they are approaching the court, if the court allows an order, then they can amend the arbitration award, right?
Right.
The agreement.
Then the arbitrator is bound by that.
Okay, right. Okay, sir. Okay, and thank you so much, sir, for sharing your valuable insights on arbitration and its impact on dispute resolution, especially for the businesses engaged in international trade. So with that, I now invite Mr. Lada, our Executive Director, to deliver the vote of thanks. Over to you, ma'am.
Thank you so much.
Truly, sir, first of all, thank you for sparing the time, and it was indeed wonderful session, and so many new things we have come to know, and I'm very hopeful that this will spark a discussion and us in the audience or the listeners. They would also try to learn more about and to implement the arbitration in their daily business transactions. I just wish that, and the purpose of these sessions is just same. And of course, sir, from you, we are learning a lot, and with your help, IAC would be doing good. And of course, we will be able to benefit our members with your expertise, with your knowledge. Thank you again, and we look forward to meet you again and again, sir. Thank you so much, sir.
Thank you. Thank you so much for the very kind words and for the opportunity, which I really enjoyed. And I look forward to remaining connected and look forward to taking this initiative forward and achieving some of the outcomes that seem very possible based on the discussion we had today. So let's work towards achieving those outcomes.
Yes, sir.
Thank you, and all the best to all of you and all your members.
Thank you,
sir. Okay, sir. Thank you so much, sir.
Thank you.
Namaskar.
Thank you so much.